I want to discuss some other claims that can be made under Ontario and other statutes across Canada for reinstatement. Let me give you an example. The Employment Standards Act of Ontario contains what's called a reprisal remedy, as does the Occupational Health and Safety Act. So what that means is that if the employer terminates someone because of the threat to file a complaint or the actual filing of a complaint, then there can be a statutory remedy of reprisal under the relevant legislation. This is very important because what that means is that the claim for lost income continues until the date of the hearing and any appeal of that decision. So if the hearing takes a year and a half and if there's an appeal or review and that takes another year, then the clock for lost income is always ticking. Also, the claim for reprisal doesn't have to be the only issue that led to the termination. So if the employer says, for example, yeah, well, Harry's performance really sucked and he was doing this wrong and that wrong, and yeah, I was a little pissed off that he filed a complaint, but that wasn't the only reason. The reprisal factor just has to be influential. It does not have to be the sole reason for the action that was taken. So it's a big difference, and the claims can be considerable. So there's also something in the Employment Standards Act and the Occupational Health and Safety Act and other legislations that I'll detail momentarily that creates something called a reverse onus. This is foreign to common law. What the reverse onus means is that once the complaint is filed, the employer is presumed to be liable. Now the employer's got to dig its way out of the tunnel and show to the hearing officer that, yeah, I didn't really do that. These are the true reasons for my action. So this is a very important procedural advantage to the employee. And there's a host of statutes that I'll detail in the summary below that have that reverse onus obligation put upon the employer. It's a big difference. So typically in a claim, I've used reprisal as an example, but there are many other types of claims under these statutes for basically adverse treatment pursuant to the Employment Standards Act or the relevant legislation. So there's a claim you can make for lost income at the date of hearing, any expenses you have incurred in looking for other employment, and also mental distress damages or aggravated damages. Now, those damages tend to be modest in this environment, around $5,000 or $7,000. They're not terribly significant. Also, there can be a claim made for reinstatement. And where reinstatement is not awarded, these statutes tend to offer compensation based on a formula of 1 month for every year of service. So if you've worked there 10 years and you don't become reinstated, then the general rule is to award 10 months as lost compensation in lieu of reinstatement. So again, these are particularly important remedies. The whole concept of this type of remedy is based upon the same words in the Human Rights Code of make whole. So it's foreign to common law. Wrongful dismissal concepts are foreign to this analysis. It's a completely different procedure, and one, as I say, very much in favor of the employee with the reverse onus. So it's the general interpretation of these legislations has been one intended to give a liberal and open reading, a generous reading in favor of the employee rights. So this is a huge advantage to the employee. I've used, again, reprisal as an example. It's not limited to reprisal. And the summary that I will provide shows other examples of other violations of relevant statutes that can give rise to this type of remedy. It's very important to know the difference. It can be a huge remedy in favor of the employee. The damage claim made for loss of reinstatement is non-taxable. Damage claim for mental distress damages, non-taxable. Damage claim for lost income, taxable. So make sure you know your rights.